Welcome to the Probate Professor.
Hey everyone, welcome in to an all-new episode of the Probate Professor with attorney Taylor Waite over at the Clear Counsel Law Group. I am your host, Mike Leon. You know, navigating the Nevada probate system can be a little overwhelming, folks, but you don't have to do it alone. Taylor is here to help, and he's been helping Southern Nevada families clear the legal hurdles and protect their legacies with confidence. Taylor, it is good to see you, sir. I want to talk to you at a high level here about the word probate. How would you define it in one sentence, and why does the word kind of cause a little bit of anxiety for families out there?
Hey, Mike, it's great to be with you. So probate, I think the general broad overview, it's the court process where you're wrapping up the affairs of someone that's passed. So gathering assets, resolving creditors, and then at the end of that process, distributing to the rightful parties what they're entitled to. A lot of details and a lot of steps that go into that, but as a broad sweep, that's the idea. With respect to that anxiety for the families, I mean, they're already going through what's a difficult time, an overwhelming time. And when they hear the term probate, I mean, they're going to think it's going to take a really long time and cost a lot of money, even sometimes people will feel it's going to deplete whatever may be there. And it certainly has a cost and it can take some time, but it's more reasonable than people may think. And we can certainly help them through what can be a difficult process.
Can we stay on that, Taylor, for a second? Because how would you tell clients on average how long probate does take in the state of Nevada? And in your experience too, like what are some of the biggest bottlenecks you've seen in the court system regarding probate?
Yeah, so the length of probate is an obvious concern for the families, particularly people that want to move on. And I often like to describe or explain to people that probate in Nevada is driven by nature and value. And if I can briefly, what I mean by that is the nature of the assets, whether that's real property or bank accounts or cars, specifically real property, when that's involved, that might change the length of the process. And then the value as well. Assets, if net assets are under 150,000, then the process can be different or is different. So as far as the timeline, really rough timelines might be if the net value of the assets are under 150,000, reasonably within 3 to 6 months, if everybody's diligent, you can work through the process. And if the assets are greater than 150,000, Nevada law requires a longer process with additional steps and requirements. And that process can take 8 to 10 months at least, and not unreasonable for it to take even 12 to 18, depending on the complexity and the parties involved, things like that. I mean, we've had cases in the office that go on for years. Typically, those are litigated cases, right, where you have parties that are fighting on both sides, incurring a lot of attorney's fees. But more typically, for your uncontested matters, the goal is to wrap them up within 12 months. And again, on that lower side, under 150, within 3 to 6 months. So it takes time. But for the tasks that have to be done, I think that's a pretty reasonable time frame. With respect to the bottlenecks and what can pinch the process, I think I see that in sort of two different lights. Number one, you do have a bottleneck in the court, which is a natural bottleneck. It's more a function of what the court can handle. I can tell you in Clark County, Nevada, for example, they hold probate court only a couple times a week and only take a certain number of cases on each of the probate days. So when the day fills, they just set it for the next day. Just as an example, these last few weeks, we're probably setting hearings 6 to 8 weeks out from filing. So as a bottleneck, that just a natural sort of bottleneck is that with the courts. I think it's a more common bottleneck actually as a problem we run into with families, and not the families themselves. It's more a bottleneck as far as their access to information. You may hear me repeat myself that probate in Nevada is a subject of nature and value of assets, but we have to have information in order to determine the nature and value. So when someone passes, unfortunately, but also fortunately, institutions, banks, and mortgage companies don't communicate with just anyone. Oftentimes, you're going to have to wait until someone is a court appointed to have authority to act. So oftentimes, it's the limit or the inability to access information that's going to be the greatest bottleneck to moving the process along. And then we have to get into the process, get people authority, and move through it that way. Once someone has authority, it's smoother, but that will certainly, if no information is available to the family when they start, it makes it difficult.
Taylor, let me ask you, because you stumbled upon it an answer ago about money, right? The fees. So we've got filing fees, attorney fees, maybe some executor commissions. You can explain all this, but how much of, and I'm using air quotes, a haircut does an average Nevada estate kind of go through? Like, how much does it take just to go through the process?
That's a great question. And the cost of the process, I'm going to explain a broader concept that most people don't run into, but is still a question that people have, which is how much is the state going to take, or how much is the government going to take as part of that haircut? And the reality is, certainly in the state of Nevada, and for most people, as far as an inheritance tax or anything like that, nothing. There's really no inheritance tax. There is no inheritance tax in the state of Nevada. And there are a few states that do have an inheritance tax. And those, you just have to pay attention and make sure and ask that question. There are federal inheritance taxes, but most people are well below that limit, which is currently $15 million per individual. And then if properly planned and you make the right elections, then a couple can elect as much as $30 million to pass without any sort of an inheritance tax. But more specifically in Nevada, there's no inheritance tax. So the state itself doesn't just take anything. It's so the fees and the costs really are the attorney's fees that are going to be paid to the attorneys and the office and those that are helping. And then the costs are going to be court costs, publications, things like that. So again, repeating myself, nature and value is going to drive that as well. And you'll continue to hear me reference the $150,000 limit, because that's really the key sort of threshold in Nevada. Under $150,000, it's a quicker, shorter process. There's still some complications there. And over $150,000 is a longer process. As much as I hate on camera, certainly giving too specific information about fees, I think it's fair to say that if you're under $150,000 without too many complications, a broad range, maybe $3,000 to $6,000 on that for those types of estates. And if you're greater than $150,000, you're going to start probably close to $8,000 for your pretty simple and straightforward. And then they'll go up from there as far as, and it wouldn't be unheard of to see probate cases with lots of, whether that's fighting or lots of complex issues, 50,000, 100,000. I don't know if folks are paying attention to the Tony Shea probate estate that's going on here in Nevada. But if you were to look at those court filings, I think you'd see attorneys that are seeking attorney fee awards in the hundreds of thousands. So obviously the complexity will make a difference. But your ordinary, straightforward probates, yes, there's going to be a cost. I think it's reasonable based on the work that's complete and the time that it takes.
Taylor, let me ask you, because if my understanding is correct, isn't probate a public process? So like anybody can actually just walk into the courthouse or go online and see exactly what's owned and who's been left to. Is that correct?
That's correct. So they're public filings, and there are certain things based on certain Supreme Court and certain filing rules, certain things you can seal from the public, but most of what we're going to see in a probate case is not going to comply with those rules and is going to be filed publicly. And that can be a great concern to people. I don't know that most people are out there searching the probate filings. Certain individuals going through probate, like the Tony Shea one again, I'm sure is interesting for people to look at, but most of the time people aren't searching those. An important exception might be real estate, is you do have property investors and realtors and others in that arena that are interested in the probate filings that have property attached, and they may be reviewing those cases to see if that's something they can invest in or if they could be of service to the parties. In fact, we have clients sometimes that'll call pretty upset that a realtor called them out of the blue. And I can tell you publicly, we generally do not disclose phone numbers. There are some exceptions to that in the court rules that do require disclosure, but generally. So I don't know how they get the information, but the realtors, the more aggressive ones, can find these folks. But having said that, while it is a public process, there are some mechanisms that families can use if that is a concern to them, that they can bypass or forego some of those filing requirements. To be clear, to use those, you have to have consensus among the parties. So let's assume there are 4 children that are going to inherit from the parents, and they would prefer not to disclose the full nature of the assets of the parents. So Probate in Nevada, they're required to file a formal inventory, formal accounting. But if all of the interested parties all sign waivers, then you can forego that obligation and not file that detail with the court. But again, it requires consensus from every interested party. If one person wants it done, then it has to be done. And then there are other ways as well. Nevada law has the normal probate process, but also what's called independent administration, which allows for administrators under certain parameters to do certain things, selling a property, administering certain administrative matters, so property expenses, sometimes pursuing certain claims. So under independent administration, it would also provide a mechanism or a way for a family to pull some of that private information from the public realm.
Taylor, let me ask you, I'm sure there's a myth out there and you can kind of dispel it that, well, if I have a will, I don't have to go through the probate process. Can you kind of clarify why a will may just actually be just a set of instructions for the probate court rather than a way to actually bypass the probate process?
That's a great question. And honestly, so the question of whether or not a will avoids probate in Nevada has to be one of the questions we get most often. And honestly, it's one of the most where clients are most frustrated by the response, because there is an assumption that the will alone should allow us to just manage mom or dad's affairs. But the way you describe it is right. A will is better described as a list of wishes when the testator has said, this is who I want to manage my assets, and this is how I want those assets to be distributed. But in order for anyone to accomplish that, you first have to go to court and ask the court to prove that as a valid will, appoint that individual as the administrator, and then once that's confirmed with the court, then to move forward with the administration. And it makes sense in the context of what we're trying to accomplish, which is the intent of the testator, the individual that passed. The court's primary goal really is to do what they want to have done. But to do that, it is important that that information is made, if not public, we just talked about that, but at least all the parties with an interest in it, whether those that are identified in the will or the estranged sibling or child, that they have an opportunity to at least review the information before you move forward to administer per the will.
Taylor, let me ask you, because we've spent a lot of time focused on why people should avoid probate, right? Getting their affairs in order. But is it ever actually better, or have you seen instances where it's better for the family to actually go through the probate process?
We do. We have seen that. We have some great attorneys here in the office that do litigated matters. Unfortunately, as we've talked about, it is a highly emotional time. And the reality is sometimes as folks get older, they are taken advantage of. So the question is, are there times when it's better to go through probate, even though it may take more time and cost more money? I think the prime example and the real answer is when there is an issue among the family about how assets are to be distributed, if there are issues about the validity of a will, because the probate process is going to give those individuals, whether through their attorneys or on their own, give them an opportunity to go to the court and explain their position, hopefully a legal position, and the facts that support that, allow them to be heard, and then allow a decision maker to make, with the understanding there could be appeals, but the idea is that to get a final determination that the parties, if not happy with, at least can live with, to understand that they were heard, a decision was made, and they can move on. So we want to avoid probate, but in those situations where there's a contest or an issue or a matter that really needs to be dug into, then probate's a good place to do that and the best place to do that, I think.
Well, Taylor, you just mentioned about avoiding it. So let's talk to the Nevada listener out there who wants to spare their family the court process entirely. Piece of advice you would give to them, single most effective tool that they could start using right now?
I think the single most effective tool for avoiding probate is your standard revocable trust. And that is most effective. I don't believe it's the only effective tool, but certainly the most effective across the board is a revocable trust. And if I can take just a minute, and I'll be brief, to make sure we understand what a revocable trust is and what it is not. As we've talked about the misconceptions about what a will is or is not, and how long probate may take or may not take, as far as those costs, there are lots of issues with revocable trusts as well. They will avoid probate, and it's a great option to do that. Just want to make sure people understand that your standard revocable trusts, which is mostly what you're getting on LegalZoom You can get others, but that's mostly what people are talking about. Does not provide creditor protection, doesn't provide, any asset protection, no protection against the IRS. Sometimes like to describe it as a box, but if I create my revocable trust, my box is open. It's wide open to whatever I may do wrong. So certainly the most effective method is that trust. And we're not going to get into that today, but there are other methods as well, because trusts can be expensive. So you got the pensioner, right, that wants to pass things on and wants to avoid probate. So there are other options available to them. Things like beneficiary designations on almost everything these days. Your standard checking, saving account, go into the bank, tell them you want to list a beneficiary on that account. Even the DMV, you can ask the DMV for a form that you can fill out and submit, which will allow you to pass your vehicle upon your death to whomever you want to give it to. There are other methods as well. Joint ownership, just again, something to be careful with joint ownership, though. If it's a spousal situation, joint ownership is a great method to make sure it transfers without probate. I don't like using joint ownership as a method to transfer to children or anybody else. There are other options that don't bring with it some possible other implications, but certainly an option as well. So there are good options. Trust being, again, I think the most efficient of all of them, but still important if you're looking at things like that to consider what the nature of your assets are, how would you like them to pass, and to consider that there are free options that will accomplish the same thing.
Yeah. Taylor, thank you so much for the time, the insights, breaking this all down. I appreciate it.
You're very welcome. Thanks again for having me, Mike.
And thank you to everyone out there for listening to this installment of the Probate Professor. If you're navigating right now a probate matter, don't let the legal process overwhelm you. You can visit Taylor and the team at clearcounsel.com and get that clear clarity that you need. Do me a favor, one more favor before you go. Hit like, hit subscribe, leave a review, comment, share the episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.